Welcome to the Fearless Floyd Show. I am your host, as always, Fearless Floyd. Today, we're going to talk about a very important Supreme Court ruling, not from this session, but from 2013. And it would behoove everybody to really pay attention to this case, its ramifications, how it's applied, and particular uses by different entities. Just leave it at that. So if you like my channel, subscribe to it. If you like this video, you like my other videos, hit that like button, subscribe, share this video, even though my stuff's copyrighted. Don't sell it. Don't sell my material. I'm not a doctor. I'm not an attorney. I don't give legal advice. I don't give medical advice. I do this as a hobby. I do it for fun because I like it and they're interesting topics that I like to talk about. If you want to contact me, you can contact me at TheFearlessFloydShow at yahoo.com. And I'll get back with you as quickly as possible. So without further ado, we're going to dive right into this. And I'm going to share the screen here. First, I'm going to pull up an article. This is from The Guardian. And right here you see, I don't think there's a date on this. But U.S. Supreme Court rules human genes cannot be patented. Court calls DNA a product of nature, contradicting biotech firms' argument that isolated strands have markedly different structure. Okay. Medical groups challenged patents on 2 genes linked to breast and ovarian cancer owned by Myriad Genetics. U.S. Supreme Court has ruled unanimously that natural human genes cannot be patented, a decision that scientists and civil rights campaigners said removed a major barrier to patient care and medical innovation. The court on Thursday held that human DNA was a, quote, product of nature, unquote, a basic tool of scientific and technological work, thereby placing it beyond the domain of patent protection. It struck down patents held by Myriad Genetics, Inc., a Utah company, on 2 genes linked to a higher risk of breast and ovarian cancer. But, here's the but, because you know there's always a but. But it also said that synthetic genetic material could be patented in a mixed ruling for the biotechnology industry, which has argued that patents are necessary to recoup the billions of dollars it spends on research. All right, so without getting in all to the minutiae of this article, I'm going to dive right in to the next. Kill that. And I'm going to show you this real quick. It's interesting. Now, this is from the U.S. National Library of Medicine, National Institute of Health. Okay, so I don't know what the NCBI stands for, but we're going to find out here later. Anyway, patenting genes. What does Association for Molecular Pathology versus Myriad Genetics mean for genetic testing and research? This is a Juris Doctorate, so she's also an attorney, whatever MPH is. And all right. So basically, this says during its 2013 term, the U.S. Supreme Court ruled on a challenge to a patent held on genetic tests for certain genes that increase the risk of breast cancer and ovarian cancer. The patent gave one company a monopoly on genetic tests that involved isolating natural deoxyribonucleic acid, deoxyribonucleic acid DNA strands and creating synthetic complementary DNA or cDNA that mirrored the original isolated strands with slight alterations. The court ruled that synthetically created complementary DNA is patentable, while isolated natural DNA is not. This installment of Law and Public's Health examines the court's decision and its implication for public health. And then it goes into the minutiae of the case. So, and with that, we're going to just dive right into the actual opinion of the court. And here it is. And of course, you see it's 22 pages. From the October term, 2012, their term goes from October 1st to May 31st. That's a Supreme Court term. And this is what they call a slip opinion that hasn't been published yet. This is actually in it's 133 Supreme Court, volume 133, page something of the Supreme Court Reporter. I have it. Anyway, Association for Molecular Pathology et al. Means there's more than one plaintiff versus Myriad Genetics Inc. et al. More than one defendant. Certiorari to the United States Court of Appeals for the Federal Circuit. And there's the number. Argued April 15th, 2013. Decided June 13th, 2013. And basically, this just gives you a synopsis right here. What the case is about. Justice Clarence Thomas, delivered the opinion for the court in which Roberts, Chief Justice, and Kennedy, Ginsburg, Breyer, Alito, Sotomayor, and Kagan joined, and in which the late Justice Scalia joined in part. Justice Scalia filed an opinion concurring in part and concurring in the judgment. Basically, what Scalia said was it was over his head, but he relied on past Supreme Court precedent or lower court precedent to solidify his concurrence with the opinion of Clarence Thomas. So here it is. Thomas delivered the opinion. And basically, this is going over the same thing that I said before. And this goes, on and 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 on. I could read all this. This tells you all about the case. Start citing case law and stuff. So basically, what this case is about is the double helix of DNA. You have those swirls like that. And then you have the crossbars, like the ladder rungs in between there. What this company has done is been able to take out those crossbars, which are human DNA, and put in synthetic DNA called complementary DNA right here, that stuff. So when they're, when they're able to do that, they've created a patentable genetically modified organism or genetically modified DNA. That is patentable. That's what this case is all about. This is the holding of the court. So that's all that matters right there, the holding. So I'm going to read it to you. Held, this is Justice Thomas, a naturally occurring DNA segment is a product of nature and not patent eligible merely because it has been isolated. But complementary DNA is patent eligible because it is not naturally occurring. Pages 10 through 18. Later pages. A. The Patent Act permits patents to be issued to, quote, whoever invents or discovers any new and useful composition of matter. Section 101. But, quote, laws of nature and natural phenomena and abstract ideas, unquote, quote, are basic tools of scientific technological work. I'm going to leave out the quotes because these are like internal quotes of quotes. It means they're coming out of several different bodies of work that lie beyond the domain of patent protection. Mayo, Supra, at, and they haven't even put the page in yet. The rule against patents on naturally occurring things has limits. However, patent protection strikes a delicate balance between creating incentives that lead to creation, invention, and discovery, and impeding the flow of information that might permit, indeed spur, invention. Id at, well, same citing, that's what id means, Latin. This standard is used to determine whether Myriad's patent claims or patents claim a new and useful composition of matter or claim natural occurring phenomena. Myriad's DNA claim falls within the law of nature exception. Myriad's principal contribution was uncovering the precise location and genetic sequence of the BRCA1 and BRCA2 genes. Diamond versus Chakrabarti, and I'm not going to give you the citing, you can read it, is central to the patent eligibility inquiry whether such action was new with markedly different characteristics from any found in nature. Myriad did not create or alter either the genetic information encoded in the BCRA1 and BCRA2 genes or the genetic structure of the DNA. It found an important and useful gene, but groundbreaking, innovative, or even brilliant discovery does not by itself satisfy the Section 101 inquiry. And see that different case right there, Funk Brothers Seed Company. Finding the location of the BRCA1 and BRCA2 genes does not render the genes patent eligible. New compositions of matter, Section 101. Myriad's patent descriptions highlight the problem with its claims. They detail the extensive process of discovery, but extensive effort alone is insufficient to satisfy Section 101's demands. Myriad's claims are not saved by the fact that isolating DNA from the human genome severs the chemical bonds that bind gene molecules together. The claims are not expressed in terms of chemical composition, nor do they rely on the chemical changes resulting from the isolation of a particular DNA section. Instead, they focus on the genetic information encoded in the BRCA1 and BRCA2 genes. Finally, Myriad argues that the Patent and Trademark Office's past practice of awarding gene patents is entitled to deference, citing JEM Ag Supply Inc. versus Pioneer Hybrid International Inc., a case where Congress had endorsed a Patent Trademark Office practice in subsequent legislation. There has been no such endorsement here. The United States argued in the Federal Circuit and in this court that isolated DNA was not patent eligible under Section 101. C. Complementary DNA is not a product of nature, so it is patent eligible under Section 101. Complementary DNA does not present the same obstacles to patentability as naturally occurring isolated DNA segments. Its creation results in an exons-only molecule, which is not naturally occurring. Its order of the exons may be dictated by nature, but the lab technician unquestionably creates something new when introns are removed from a DNA sequence to make complementary DNA. Now let me repeat that sentence. Its order of the exons may be dictated by nature. Those are those crossbars, and there's 2 per bar. But the lab technician unquestionably creates something new when introns are removed from a DNA sequence to make complementary DNA. D. This case, it is important to note, does not involve method claims, patents on new applications of knowledge about BRCA1 and BRCA2 genes, or the patentability of DNA in which the order of the naturally occurring nucleotides have been altered. It's affirmed in part, reversed in part. So basically, what Justice Thomas did was allow the introduction of complementary DNA into a living organism, and there could be some type of type of technology incorporated with that introduction into that entity or organism that would do the work to replace the, what they call it, the exons, the introns, or the introns with the exons, switch them out so that the product of nature now became not a product of nature. So it is patent eligible under Section 101. So basically, that stuff right there, product of nature, is not patent eligible merely because it has been isolated. But when it's been incorporated with that, it is patent eligible because it's no longer naturally occurring. So let's say they used some kind of a bot. Yeah, bots are pretty popular these days. So maybe they use some type of a bot to carry this particular synthetic material to replace some of that naturally occurring material. Then, whatever that was will become patentable. And who owns the patent? Whoever created that. So whoever created that, and you know, they bumped off of it. Could be, could be. Who knows? I'm not telling. All I know is this is a Supreme Court case. Decided in 2013. And it could or could not be happening. I don't know. But as always, I'm your host, Fearless Floyd. Thanks for watching my video. I hope I educated you. Hope this one sticks around on this platform for longer than 30 minutes. Unlike the last one that got booted in like less than 30 minutes after 9 views. And if you like the video, hit that like. If you want to share it with somebody, open some eyes, hey, you're more than welcome to kick it on down the road, folks. Subscribe to the channel if you like it. You want to hear some more stuff. I'm going to do some more on this little topic here. Carry on. I have to do this in a multiple part video. So with that, guys, thank you. Appreciate you for being here. Have a happy and safe weekend. Adios.